for being here. Minister, I had the same concerns that Senator Carignan has, and I'm really concerned that this is a very important issue, and it's a very difficult issue. It's an issue that needs a lot of studying because extreme intoxication, it can happen with many things. As we need to have expert evidence, not just on the usual experts we have, but we also have to have experts in chemical, experts, scientific experts. And I have a lot of questions, but I want to ask you, my biggest anxiety is what will negligence look like? How will the prosecutors prove negligence and the standard of care? Because, and I agree with everything Senator Carignan has said, but I also want to take this opportunity to say, how will they prove that? Because it's very, very difficult. The person doesn't know. Say you have had some food to eat that you've not eaten before, and then you have something to drink, and then you go into an extreme intoxication. How is that negligent? I'm really struggling with this.
Monsieur le Ministre.
Thank you, Senator. Let me reassure you, if I can. First of all, these cases are extremely rare, and what we are doing with this piece of legislation is filling a gap that has been created by the Supreme Court in again, a very rare set of cases where it's not just extreme intoxication, but it's extreme intoxication leading to a case of automatism. So all the other cases of extreme intoxication are already covered by the criminal law and by criminal law principles. It's the general intent offense, and prosecutors, judges, and participants in the criminal law system are used to those standards. So we're closing a small gap based on the guidance the Supreme Court has given us. With respect to criminal negligence, it is a known standard. We use criminal negligence as a standard in a variety of different offenses. There is a reasonableness standard, which is, what would a reasonable person do, or what ought a reasonable person to have done. And so it's an objective standard. And again, it is something that is known to prosecutors. It is something that is known to judges and participants in the system. And the question becomes, was there a marked departure from that standard by the person in question in ingesting intoxicants?
Minister, I don't mean to be rude, but I just have a minute. So yeah. I just want to say that that's the challenge for me. It's what a reasonable person would do. This is outside what a reasonable person would do. If you don't even know you're doing something wrong, like say we have the reasonable test on driving, and you don't drink and drive, but when you've eaten something and then you drink something and you go into extreme addiction or intoxication, that's the challenge. It's not a reasonable person test for me. That's why I think we have to study this further.
Well, I think the answer, Senator, is that it is in the act of ingesting intoxicants that the criminal negligence or the reasonableness standard is applied. If there was something, if there was something that ought to have triggered that this could have led to violent behavior in a person's past or with respect to what's being ingested, and that's in the vast majority of this small fraction of cases, then that person will be found to be negligent. If it was completely innocent, and there have been examples, if it was completely innocent, taking prescription drugs and there was a reaction that could not have been predicted, that's what the court found unconstitutional about the previous law. And that's the only part that we're excluding here.
Mr. I have so many questions, but I must respect Senator Miller-Duchesne. So.
Thank you.
Senator